Welcome to Chapter 13, the Juvenile Justice System. I know that some of you had indicated you wanted to get into juvenile justice as a probation officer, as a defense attorney, even one student wanted to get into it as a judge. So let's talk about the juvenile justice system. The student learning outcomes for this module, this chapter, are to describe the child-saving movement and its relationship to the doctrine of parens patriae. List the four major differences between juvenile courts and adult courts. Explain important Supreme Court cases with respect to juvenile justice. I got back in there again. Oops, where am I going? There we go. Explain the four major differences between the juvenile courts and the adult courts. The juvenile court, first enacted back in 1899. Before that, they didn't have any courts that were designated as juvenile courts. And there's differences between the adult courts and juvenile courts. Number one is there's no juries. And the Supreme Court will talk about this in a few minutes, but the Supreme Court reaffirmed that, the juveniles do not get juries. Maybe some of you have actually been through the juvenile justice system. I had been. I had several traffic tickets in my teen years before I turned 18, and those ended up going to the juvenile justice system. They use different terminology in the juvenile justice system. We'll talk about the terminology as we get later on in the end of the chapter here, but it's different terminology. There's no adversarial relationship. Look back to chapter 9 or 10, I believe it was, when we talked about the jury trial. Remember, we talked about the adversarial relationship. In other words, it's not out seeking the truth. It's all about the finding the truth. The adult court is not about finding the truth. The adult court is about winning. So they don't really care about the finding the truth. But in the juvenile system, we're looking for the truth. So there's no adversarial relationship. There's complete confidentiality in a juvenile court. In the courtroom, there's only the people that need to be there. You can't have public trials for juveniles. And the cases aren't published. In other words, they don't get you can't get the court transcripts, which you can get for adults. And by 1945, all states had put in the juvenile court system within their states. So let's talk about the difference between juvenile delinquency and a status offender. Think about those two words for a minute. Juvenile delinquency, status offender. You think of a juvenile delinquent, what do you think of? That little crook. He's doing something. He's vandalizing things. He's stealing things. He's shoplifting, something like that. So that's exactly what it is. Juvenile delinquency is behavior that is illegal under federal or state law, and can be committed by somebody who's considered to be a minor. Now in California, the age of majority is 18, so anytime you're under the age of 18, it's a minor. Then there's a status offender. Does that mean when they do something wrong they gain some status? No, not at all. What a status offender is a crime that's a crime only because the person committing it is a minor. So let's think about some crimes that a person could commit that wouldn't be a crime if they were an adult, but are a crime that they're a minor. I'm sure you've thought of some already. But some of the crimes are drinking underage. You have to be 21 in California, and as a matter of fact, all states now, you have to be 21 to drink alcohol. So if you get caught drinking underage, that's a status offense. Smoking under the age of 18, truancy, cutting school, running away from home. Those are all offenses that you can normally do once you're over the age of 18, but under the age of 18, you can get in trouble for it. Matter of fact, if you're over the age of 18, some of your parents encourage you to run away from home. Time to get off the couch. Time to launch. So some of the most important Supreme Court cases, the case to end all cases here, the number one important Supreme Court case that pardon me for a second here, the number one Supreme Court case is in re Galt. And you notice in Supreme Court case, or excuse me, in juvenile cases, most of the time they'll use that in re, and it's in regards to, or it's actually a Latin term. But anyway, instead of using the state versus as in re in the matter of basically of Galt. And as this case came down in 1967, and if you think about our earlier discussions, especially about the history of law enforcement, what also was going on in '67? That was the push to civil rights. Remember the Civil Rights Act in 1964? A lot of these major Supreme Court decisions like Miranda came out in '67. So there was a lot of push towards reforming the system, and juvenile justice was no different. And now there was a number of cases that led up to Galt, and we'll talk about those in a minute. But Galt basically said that what happened with Galt is he was a juvenile. He was arrested. They had a hearings, some pretrial hearings. They sentenced him. They held him in custody, and they never once told his parents. They didn't tell his didn't tell him he had the right to have a lawyer. Didn't tell him he had the right to remain silent. Anything like that. And because they felt they didn't have to, he was a juvenile. Juveniles are treated differently. The Supreme Court said otherwise. The Supreme Court said basically that juveniles get due process. All the rights that an adult would get, the juvenile would get, except for one. We'll talk about that in a minute. So some of the cases that led up to Galt were Kent versus United States. That was a '66 case, and it was a little bit less than Galt, and it said that it was entitled to due process. We've talked about due process in other chapters here, but due process basically means that the government, the police, the courts all have to follow the Constitution. In other words, you can't do a search. You can't force a confession out of somebody. You can't not let them cross-examine people. A couple other important cases. In re Winship, which is back in 1970. Before 1970, in a juvenile trial, it was just a preponderance of evidence, similar to a civil court case. I think we talked about that grain of sand. You know, you got 2 buckets full of sand. You take 1 grain out of the one and put it in the other. They both weigh exactly the same. Take 1 grain out of one, put it in the other one, and it weighs just a tiny bit more. That's a preponderance of evidence. Winship moved it up to a reasonable doubt, beyond a reasonable doubt, which is the same standard for adults. McIver versus Pennsylvania in '71 reaffirmed the right that the juveniles do not have a right to a jury trial. However, the Supreme Court is looking again at that issue. They may rule on it this year, they may rule on it next year, but they're looking at that issue again about juveniles and jury trials. And Breed versus Jones, '75, said that you can't have double jeopardy in a juvenile case. In other words, if the case was heard and adjudicated, and when adjudication, remember back from our other discussions, adjudication means that the courts have ruled on it and some kind of a resolution has come out of it, that if it was adjudicated in juvenile court, it can't come up again in adult court for trial. So today, they've moved away from that parens pater and more towards a formalized system of justice. Basically, what they're saying is that we want to hold kids more accountable for what they do. We're still looking more towards rehabilitation, and that's the main goal. But they do want to hold those juveniles that are just bad people, basically, accountable for what they do. And each states have different rights, and again, if you take constitutional law, you realize that the United States is broken up into 50 different states. Each state's given its own laws and when they can try kids as adults. In California, generally, it's age of 14 and above. They can determine whether you're going to be tried as an adult. And we'll talk about that more in depth in a few minutes here. Some trends in juvenile delinquency. Bullying is getting a lot of what do you call it? A lot of press nowadays. It used to be just that's a right of growing up. You know, people bullied each other. I got bullied as a kid, no big deal. Fought my way back. Matter of fact, there was a guy I used to get in beefs with when I was a kid, and we ended up getting a fight in the schoolyard one day, or just off of the schoolyard, and then we became friends after that. And I actually had him as a college professor when I went back to community college. He'd gone to college right out of high school and graduated and became an attorney, came back and taught business law. So what variables correlate highly with juvenile crime rates and factors, and what factors lead to juvenile delinquency? Number one variable when it comes to juvenile law, and it kind of makes sense there, is as you get older, you're no longer juvenile, but then again, as you get older, you also figure out that, hey, maybe crime isn't the best way to live my life. And so we call that aging out. When juveniles get to the point where they get old enough to figure out it's not a good idea to commit crime. Usually it's about 28 years old. Also, the age of onset, in other words, when the juvenile starts to become a knucklehead, is a good predictor in when the future criminal behavior. The younger the juvenile gets involved in criminal behavior, the more likely that they're going to continue that life of criminal behavior. However, if the onset is maybe 15, 16, 17 years old, that's when you get a lot of peer pressure and you get to start doing things like drugs or maybe stealing or vandalism or driving recklessly, racing, something like that. Those people usually age out a lot faster. And knowing this information, the juvenile system tries to put a lot of resources towards the very young that are starting to head down the wrong path. We're talking the 8, 9, 10, 11, 12-year-olds that are starting to head down the wrong path. Get them turned around, get them figured out that, hey, you know what, it's time to shape up. These are some factors in juvenile delinquency: family life, single parents, school life, if they're dropping out of school, learning disabilities, community life, social disorganization theory. We discussed that in Chapter 2. You know, if the society is all messed up and they're looking towards gangs and stuff. Peers, huge factor, especially among the 14, 15, 16-year-olds. You get a lot of peer pressure to do stupid things. And also your individual choice. I mean, there's some people that are just bad people. You look at Jeffrey Dahmer. We talked about the Dahmer case and crime causation. Dahmer ate his victims. Dahmer was a bad person from very young, killing little animals and stuff like that. Police arrest about 1.2 million youth a year, and we can also act what's called loco parentis, which means we're there to protect the kids. In California, the authority to take kids into protective custody or to act in the lieu of parents is in the Welfare and Institutions Code. Basically, if we have a kid that's hurt, we can act in place of the parents and get the kid medical care if the parent's not there. Also, if a kid's in danger, we can take them into protective custody or get them some help in lieu of the parents per the Welfare and Institutions Code. Discretion, huge. We've talked about discretion all semester long, and the police have discretion, the courts have discretion, the corrections has discretion, and once again, the juvenile justice system has discretion. When you're dealing with the youths, remember that, my cousin Vinny, the youths. When you're dealing with the youth, consider the nature of the offense. Is it a really bad thing, or is it just something minor like smoking cigarettes or something like that? Look at their past history. Look at the setting of the offense. Is it by themselves, or are they in a group of people with a gang, something like that? Look at the willingness of the parents to take disciplinary action. I know a lot of parents are checked out nowadays. They don't bother to deal with their kids, or even worse, instead of letting their kids, holding their kids accountable, they get in there to defend their kids. Maybe you've seen kids take on their schools when it should be the parents saying, you know what, the school's right, you deserve disciplinary action. The attitude of the little punk. If the guy's got a bad attitude, he might need to get part of the system. That's one of the few times you really want to take care of the attitude by doing that. And also race and gender. Some races are disproportionately taken on by the juvenile justice system, and they don't get a fair shake, based on where they're living. I grew up in Oakland. As you know, I'm Caucasian. I grew up in Oakland, and there were times when I was hanging around a mixed crowd where we'd get jammed up by the police. Sit on the curb, put your hands on your head. But with a group of Caucasian people, it usually wasn't the case. So yes, there is definitely a race differential depending where you're from, and also gender. Females don't tend to be involved in as much crime as males. However, that's quickly changing. More and more juveniles are getting involved in criminal activity. Describe the 4 primary stages of the pretrial juvenile justice procedure. Check out this guy's shirt. It says "Fearless" on the back. I doubt it at this point. 4 stages are intake, pretrial diversion, transfer to adult court, and detention. So intake. The intake officer, when you take a person down to juvenile hall, they have a lot of discretion. They can choose to dismiss the case. They can divert the offender to a different program, such as rehab or drug treatment, something like that. They can file a petition. Remember I talked about the different terminology. In the juvenile court it's called a petition, and remember in the adult court it's called a complaint or an indictment. But in juvenile court it's called a petition. Or they can transfer the case to adult court. Pretrial diversion. Low-risk offenders can be diverted out of the system. I talked about that. They can get probation. They can get treatment, if they need drug treatment, something like that. They can have to pay restitution. I've seen that especially in shoplifting cases where they got to pay some restitution to the store for the loss prevention officer's time and whatever they stole. Transfer to adult court. How do you transfer to adult court? All several ways. You can get what's called a judicial waiver. In other words, the judge is the one that initiates the transfer to adult court. Automatic transfer to legislative waiver. There are some cases where you automatically, say murder at the age of 16, you're automatically put into adult court. There's no chance of going to juvenile court. There's a prosecutorial waiver. Prosecutorial waiver means the prosecutor, the DA, is the one that does that. Remember we talked about the ultimate power the DA has, district attorney has, in chapter 9 or 10. Can't remember which one. We talked about the trial and how the DA narrows down the cases that are charged. Same thing with juvenile. Detention. It's exactly what it sounds like. Putting somebody in the jail. Except it's not called a jail, it's called a juvenile detention facility. Some of the reasons to put in there: is this person a threat to the community? If he's killed somebody or done drive-by shootings, yeah, that's a clear choice. If they're not likely to show up in court, maybe they're homeless or transient and they've committed a crime, or you want to make sure they show up in court, make sure you put them in. Protection of the child. Juveniles are some of the few people that you can throw in jail when you're not charging them with a crime. If you're just doing it for protection. Maybe they're a runaway. Maybe they're a homeless person. I've seen witnesses put into the juvenile detention center to protect them from getting hurt by the people they're being witnesses against. Explain the distinction between an adjudicatory hearing and a disposition hearing. The adjudication hearing is a process where the court determines if there's sufficient evidence to support the petition. Again, the petition is the same thing as an indictment or a complaint, criminal complaint in the adult trial. The court has this hearing, and it's more or less like the pretrial hearing that you'd have in a courtroom, except that it's not as structured. And again, they're not looking to win, they're looking for the truth in this one. Disposition hearing, that's where the judge basically sentences. Remember, in the adult trial it's called the sentencing. In the juvenile it's called the disposition. They say what's going to go on. Are they going to put them in jail? What are they going to do with them? And the judge, and it's not a judge actually, it's a juvenile, drawing a blank here. The juvenile, the probation officer, excuse me, the probation department looks at the best interest of the child and uses a lot of judicial discretion. They look a lot at the predisposition report, which is basically like the probation report for an adult. It's a predisposition report for a juvenile. Again, the terminology is different in juvenile court. So what kind of treatment programs they have for kids? Texting. No, that's not a treatment program. Probation, that's the most common sanction. Again, in the United States, that's the most common punishment anybody gets, probation. Non-secure confinement, they get foster care programs, group homes, rural programs such as those honor camps. There's one up in LA County, there's one up in Santa Clarita, family group homes. If they're knuckleheads, sometimes they send them to a boot camp environment. It's kind of like Army, you know, where they make them do push-ups and line up and march and stuff like that. And they also have aftercare programs such as counseling and educational programs, school programs, and therapy if they need it. So we've come to the end of the chapter here. Recap the learning outcomes. So we described the child-saving movement and its relationship to the doctrine of parens patriae. We list the 4 major differences between the juvenile courts and the adult courts. And we explain the important Supreme Court decisions with respect to juvenile justice. We also describe the 4 primary stages of pretrial juvenile justice procedure. We explain the distinction between an adjudicatory hearing and a disposition hearing. And we list the 4 categories of residential treatment programs. Chapter. All right, thanks a lot.